Hearing the bill on very closely, again to Minister of Finance.
Mr. Ramlogan.
My Lord, should it please you, good morning. I appear for the appellant leading Mr. Mohammed Jameh Hafiz Beg of the Bar of England and Wales, and Mr. Vishal Susran of the Trinidad Bar appears with us. The respondent to this appeal is the Minister of Finance, who was represented by Mr. Thomas de la Mare, King's Counsel of the Bar of England and Wales. My Lord, I trust that the board received a belated notification from my learned friend that he's no longer defending the judgment of the Court of Appeal on either issue that arises before the board, and that he will not seek to defend the appeal or advance any submissions. However, helpfully and quite sensibly, my learned friend has asked that his written submissions be taken as an amicus brief by the board. And to that extent, my Lord, I will, of course, refer the board to them on the understanding that they are amicus submissions. With your leave.
Thank you.
My Lord, with that in mind, I will explain to the board why we say the Court of Appeal fell into error in this matter. My Lord, the National Insurance Board of Trinidad and Tobago was established by an Act of Parliament number 35 of 1971. It is a statutory body that is established to administer the national insurance system. And its core purpose is to provide a system of social security designed to protect insured persons and their families against loss of income arising from contingencies such as sickness, maternity, injury, retirement, and death. I might pause to add, my Lord, there is some historical significance to this National Insurance Board. 1971, my Lords, my lady, precedes. What immediately preceded it was what is known as the Black Power Revolution in Trinidad. And that was a very cataclysmic event here in Trinidad, where the working class, there was an uprising by the working class. This is one of those important institutions that emerged out of the socio-political consensus that followed that revolution. Now, my Lord, this national insurance system is the only state national insurance funded system, and it is funded by contributions from both employers and employees. It provides protection to the working class, and its numbers over some 600,000 persons at present. Now, the way it's structured, the National Insurance Board, is that there's a tripartite arrangement between government, business, and that would be business meaning the employers who have to contribute, and labor, which would represent the workers or the employees. And it reflects a fairly important principle of tripartite governance in social security systems. But the clear purpose is to ensure that the interests of all key stakeholders in the national insurance system are equally represented in its administration and management. With that, I turn briefly to some of the key facts in this matter. Mr. Ferreira was appointed as a government-nominated director on the 25th of November 2017. This is all part of the agreed chronology. On the 25th of November 2017, he was first appointed, but he was appointed as a government representative nominated director. On the 20th of January 2023, 3 years later, when his term came to an end, he was reappointed again by the government as a government director. On the 19th of January 2022, when that appointment came to an end, the following day, on the 20th of January 2022, he was appointed chairman of the National Insurance Board. So he had served 2 terms from 25th November 2017 until 19th January 2022, and then immediately appointed chairman of the NIB. On the 19th of January 2024, his chairmanship expired, and on the very same day, he was immediately reappointed as chairman for a further 2 years until the 19th of January 2026. On the 20th of April, this year, 2025, there was a general election in Trinidad, and a new government was elected. And on the 4th of May, 2025, a couple of days later, Mr. Ferreira submitted his resignation, despite the fact that he had a significant period on his tenure left. And as we'll come to see, he could not have been removed by the government of the day, except on certain specified statutory grounds. My Lord, there are two issues in this appeal, and they are whether the minister's decision to appoint Mr. Ferreira should be quashed because he misdirected himself as to the proper construction of the words independent of government, business, and labor in section 32D of the Act. And secondly, whether it should be quashed because it was unreasonable or irrational as being not objectively justified by the relevant facts. Can I now take the board to the relevant provisions in the Act? And I'll start by, we've elaborated on this just for the record, paragraphs 5 to 25 of our written case, which you'll find in the electronic bundle at pages 505 to 510. But for the present purposes, I just want to take you to a few of the more relevant provisions. And we'll start with the most obvious one, which is section 3.2. And section 3 establishes the board.
Mr. Ramlogan, can you give us a page number for section 3.2?
Oh yes, I beg your pardon, my lord. It's 572.
Thank you.
And section 3 at 572 says that it establishes the National Insurance Board as a body corporate, and subsection 2 is the critical one in this appeal. It says the board shall consist of 11 members, designated directors who shall be appointed by the minister as follows. A, 3 members nominated by the government. B, 3 members nominated by associations most representative of business. And C, 3 members nominated by associations most representative of labor. D, a person who in the opinion of the minister is independent of government, business, and labor, who shall be chairman. And that's the short, narrow compass of this appeal. Now, my lords, the first to note about the composition of the board is that there is an equal representation for government, business, and labor. They each have 3 nominees. And then you have a +1. The +1 is in a separate section. And that +1 is, of course, the person who, in the opinion of the minister, is independent of government, business, and labor, and that person shall be appointed chairman. I pause to make the observation that when they say independent of government, business, and labor, the words business and labor in our respectful submission refers to, as it were, sectors of the economy, as it were. The words business and labor refer to those 2 sectors of society or the economy of Trinidad and Tobago that, along with the government, are stakeholders in a system of national insurance. What is important is that they do not refer to particular individuals, entities, associations, or groups. If there were any doubt about that, it is made clear by the fact that elsewhere in section 3, Parliament referred to such groups with the words the associations most representative of business and the associations most representative of labor. Now, the Court of Appeal accepted this at paragraph 22 of its judgment, which you will find at page 455. I don't propose to take you to it because it's accepted. And I understand it to be common ground before the board, but in any event, it simply reflects the tripartite nature of the arrangement. My lords, the difference between persons nominated by associations and the difference in the deliberate use of language, where they say independent of government, business, and labor, as opposed to independent of the associations that nominated the aforementioned nominees for business and labor, is significant, we see. One of the important significant things about this is that if the construction previously advanced by the respondent were correct, it would conceivably mean that someone from a smaller trade union, for example, that did not fall into the category of being most representative of labor or most representative of business, someone from a smaller group that doesn't fit that criteria could conceivably legally be appointed chairman. And that is why, in part, as an observation, I say that Section 2, subsection 2D is much broader and therefore references the sectors in the economy as opposed to the more limited reference to these associations.
Sorry, Mr. Logan, can you just give me that point again? I didn't follow that point.
I beg your pardon, my lord. What I'm saying is that if the construction advanced against us in this matter were to be correct, and one were to take a very limited approach, a very restricted approach by saying that, look, anyone who is independent of B and C, for example, that is to say, someone who is not a member of the association who is most representative of business or labor, would qualify for appointment on the basis that they are independent of government, business, and labor, because independent of government, business, and labor means independent of the associations that nominated B and C, that nominated the representatives under B and C.
Yes.
In other words,
you're saying that it's independence of the elements of society that the associations may represent, not independence of the associations themselves.
Indeed, indeed. And Lord, if one speaks of a person being independent of a sector or of the society or economy, one would usually, we say, and humbly submit, means that the person is not significantly connected to, associated with, or involved in that sector of the economy. Or to put it another way, it simply means that that person stands apart from that sector of the society or economy. And that's what we say it means. Now, my lords, it's interesting that this deliberate and carefully calibrated section was put in place by Parliament, because I'll come to show you a passing reference to how other similar legislation in the Commonwealth Caribbean was drafted. And all it simply said is that the minister shall appoint a chairman, a deputy chairman from amongst the members. And if Parliament simply intended for that to happen, that's all they needed to say. There would have been no need for subsection D, because they could have simply said the minister shall appoint from amongst the directors a chairman and a deputy chairman. But that is not what Parliament said. They were very careful and deliberate in carving out a niche for the chairman, because that person will have to be someone who is going to be independent and above the fray and be able to command the respect of the three groups of government, labor, and business. And that person will have to be someone who will be able to mediate the conflicting and difference and divergent opinions and sectarian interests that would obviously arise. And for that reason, there must surely be someone who is independent of the government, business, and labor, or else it undermines the independence requirement, as it were. My lords, can I take you next to section A?
Well, Mr. Ram Logan, what you've just suggested is someone who can rise above the fray, i.e. not be dictated to by any of those three sectors. Why isn't that an indication that what the lower courts have said is correct?
Well, Lord, we say that there is this independence requirement is a substantive legal requirement in the Act. And the deliberate use of the word independent of government, business, and labor, it defines the pool of candidates who would be eligible to be considered by the minister, and then he can apply his judgment and form an opinion from amongst those who fall into that category and select a chairman. What, say, my lord, is this. On any stretch, however we choose to twist it, turn it, or dissect it, someone who was serving as a nominee of one of those three groups could never, on any rational or credible basis, fall into the category of that pool of persons who can be described as being independent of government, business, and labor. For 2 terms, you were the nominee of one of those three groups, and you would be expected to seek and promote and advocate the interest and represent the views of that group. And therefore, on the exceptional facts of this case, we say that the minister erred in appointing Mr. Ferreira because he simply could not find himself in the pool of eligible candidates who would be eligible to be considered by the minister for appointment as chairman.
So no one who has ever been a businessman or is a businessman can be appointed. Is that the submission?
No, it's not. I would hasten to add, my lord, that I think if someone had past experience and there was a cooling off period, for example, I could well see that person who is no longer actively involved in that sector of society, that person would make a good chairman. But what I say is someone who is currently in your face, as it were, actively involved in one of these three groups would be disqualified from consideration. And that's the exceptional factual matrix that we have to contend with.
Yes.
I mean, could you?
But this is a part-time job, and a very important part of it is investing the fund to provide the social security that national insurance is intended to provide. And I think on your approach, if you were a civil servant, if you were a person engaged in business, and if you were the employee of someone else, those groups would be excluded from being chairman. Would that be right?
Lord, I wouldn't go so far as to say there would have to be some de minimis level of some de minimis level of a threshold. I mean, if you had one single employee, I wouldn't go so far as to say that would be.
But if you were an employee of business, then on your sufficient connection test, you would be connected with labour. Similarly, if you have a business activity when you're not chairing the National Insurance Board, you'd be connected with business. So your interpretation does cut down the persons eligible to perform this important role rather radically.
Well, my lord, I appreciate that, and my lord, one can think equally of a broad category of persons who would equally be able to fulfill that mandate, but not offend the provision. I mean, you have a professor, a distinguished professor from the university, a lawyer. You can have a retired public servant, a retired judge. There are many persons, a retired investment banker. There are many persons who equally conversely can fulfill that function in the substantive legal requirement of being independent of government.
Well, when you say a professor of a university, that person is still an employee.
Yeah.
Well, I accept that, but I think that they would not be representative of labor. I mean, the word used is not to exclude an employee, but representative of labor. And I think
what do you mean by that? Do you mean somebody? Does it have to be somebody who's not a white-collar worker? Is that what you're saying? A manual worker?
No, can't be.
No, that's not what I'm saying. I'm saying that the person would the way I interpret representative of labor, for example, would be persons who are involved in trade unionism.
No, but that can't be your case, because you've just been criticising the Court of Appeal for linking it with the association rather than with the group of society. As I understand your case, it is that if you are sufficiently associated with one of the three groups, government, business or labour, then you are not independent. Now, on your approach, that would, to my mind, exclude all people who are employees from this part-time job, just as it would exclude civil servants, government ministers, and businessmen.
Well, my lord, I don't think that that's. I don't think that I would want to go that far. I think the way I would circumscribe it and define it would be by saying that the use of the word representative has a different connotation, in that it must be something more than just disqualifying someone on account of them being an employee, because that would mean that you would have a category, the only category would be retired persons who are no longer employed.
But if it's sauce for the goose is sauce for the gander, if you do that for the employee, why don't you do it for the businessman?
Well, my lord, the businessman in question in this matter is the head of the largest conglomerate, one of the largest conglomerates in the island. They control a significant part of the workforce, and obviously their level of interaction and interdependence with the government of the day would be extraordinarily high. And the short point is that such a person, dependent as they are on the government for the success of their business venture, their business as a large conglomerate, it's easy to see why they would not have been within Parliament's contemplation for the category of persons who would be independent of government, business, and labor. But more importantly, in the alternative, I say this: if the person was serving as the government's nominee, query whether that person can overnight transform into someone who is independent of government. And those are the narrow facts in this case.
I have that point, but could I test it this way? I mean, does national insurance cover the self-employed as well as the employee?
I believe yes, it would.
It would. It would. Well, then the lawyer would have an interest. In receiving funds from the National Insurance Fund, and would come within labour. The self-employed person would be within that category. So, I mean, your interpretation is restricting the pool of people who can carry out this very important job.
I appreciate that, my lord. I appreciate that. But the self-employed person, whatever contribution he makes on his own behalf, he benefits later down the road. But if he has a large workforce, my lord, the tension in Trinidad is simply this: the employers obviously, it's going to be in the best interest of their bottom line to try and have the lowest possible contribution as in their capacity as employer. The employees, on the other hand, would want the highest possible contribution from the employer, because that's what will benefit them the most. But that is, I mean, that's the nature of the tension between these two groups in society.
But it seems to me, Mr. Ramlogan, you're introducing factors such as de minimis, whether it's a large business, a large workforce. To make any sense of this, you're having to put limitations on what is meant by government, business and labour, because otherwise you end up excluding almost everybody who isn't retired.
Well, that might be one way to look at it, my lord. But if we use the test, the simplest of saying that it's someone someone external or extrinsic to these three groups, in the sense that it's someone who is not significantly connected to or associated with or involved in the sector, and we stress the use of the word significant, then it doesn't appear as dramatic as that, respectfully. And that's our case. Our case is that it must be someone who is not significantly connected to or associated with or involved in these sectors. And the use of the word significant is where perhaps, you can have some exercise of ministerial discretion, as the case may be. But
it seems to be very challengeable. The test of significant connection seems to invite, because of its flexibility, it does seem to invite challenge as to whether or not someone has crossed that threshold.
It does, my lord, but that's precisely what the unreasonable test is. I mean, what we say in this case is that someone who was immediately previously serving as the government's nominee, and someone further who is head of one of the largest conglomerates in the country.
Those are your points in relation to this particular person, but we're looking at what the test is. What you say the test is, and you say it's significant connection, and I just wonder if that's a workable test.
Well, the viability of the test, my lord, can be viewed this way respectfully, and that is there's a broad range of discretion given to the minister to choose from amongst persons who would fall to the pool of eligible candidates that he can consider. The use of the word significant would be subject to a rationality and reasonableness objective standard test, because we've got to ascribe some meaning to the word independent. And all I'm saying, the simple case is, this particular chairman who was appointed, it's clear that he had a significant connection and couldn't possibly fall into the pool of eligible candidates that the minister could lawfully consider, because on two grounds. One, he was the government's serving nominee, and two, he is head of one of the largest conglomerates. So that however far you stretch the word significant, and whatever scope and breadth you give to the ministerial discretion, he falls outside of it, because it's just irrational to say that someone...
the head of the conglomerate point, you say that means that he's got kind of skin in the game in the sense as an employer, because if the employer contributions go up, then the conglomerate that he's a member of, that he's involved in running, will have to pay a lot more by way of contribution. So then you say, I think you're saying he's significantly connected to the business stakeholder. Yes. But yes. Were you also making a different point that because his business interests are dependent on being on good terms with the government, that's an additional government link as well as a business link arising from his role in the conglomerate? I wasn't quite clear.
Yes, indeed, my lady. I say that it's fairly, as a matter of common sense and logic. I mean, one of the largest conglomerates in a small island such as ours, where obviously the level of interface, interaction and interdependence would be very high with the government, and that is in fact the reality. I mean, so that and my lady, the third point is of course the fact that, I mean, we can't get away from the fact that he was, for 2 terms, the actual politically appointed government nominee on the board. And then to seek to transpose that person into the category of being independent of government, it just doesn't, it's not rational, it's not credible.
Can I just try an example on you, Mr. Mamrojan?
Certainly, my lord.
It is quite a common experience, at any rate in this jurisdiction, that someone who has been a prominent lawyer working mainly for one side of an area of large-scale contentious litigation, let's say for the government side in public law disputes, stops doing that on a Friday, and the next Monday he's a High Court judge sitting in the administrative court. In other words, it's quite a common experience that someone can be trusted to be independent without a lengthy period of gardening leave, or I think you described it a few moments ago as
Cooling off.
some kind of cooling off period. And nobody, I think, describes that process of appointment in this country, as far as I'm aware, as irrational.
Yes, well, my lord, I can see the merit in that, save and except, my lord, that, I mean, of course, you know, that appointment has a whole, there are many procedural safeguards that come with it in terms of security of tenure, the process for removal, the oath that you take under the Constitution, and many other things, many other trappings would reinforce the independence of that. Not to mention, of course, the process by which the person is appointed as a judge. But I do accept and see, my lord, the point you're making that you know, even on an objective basis, one's involvement in a particular activity wouldn't necessarily mean that they can't be independent. I see that. But the question here, my lord, is Parliament, we've got to take it in a contextual and purposive manner. Parliament prescribed in this act that they wanted someone independent of government, business, and labor. And the question here is, why would Parliament go through the trouble of deviating from what the standard drafting was in all the other islands, which was simply you can appoint someone from amongst the directors to say this, and it comes just beneath the aforementioned provisions which deal with the nominees from business, government, and labor. I mean, on a clear, straightforward, common sense interpretation, you wanted someone who would be independent of those three groups that were just mentioned. And how on earth could someone be independent of a group that it was just representing? I mean, for 2 terms. I mean, that, I think, my lord, is a slightly, a far different analogy. It is somewhat disanalogous to the example of a lawyer becoming a judge. I mean, when the lawyer becomes a judge, he is not running a law firm. This man continues to run his conglomerate. When the lawyer becomes a judge, he severs all ties with that law firm, and he no longer has any skin in the game, to use my lady's phrase. But here, the importance of this procedural safeguard in the public interest was to ring fence the independence requirement of this person in terms of their eligibility to be considered, so that one will ensure that this is a person who will be above and separate, not significantly connected to, separate and apart from these 3 sectors and these 3 groups, as it were. That's the clear intention we humbly submit. So, my lord, so that's my answer to that point. Now, my lords, can I? Sorry.
No, continue, please.
Much obliged. So, can I just, in that regard, can I then go next to page 575? If I go to 575, section 8, and we'll see that the board is to operate and manage the system of national insurance and exercise functions, duties, and powers conferred upon the Act by any other written law. I then go to section 9 at page 576. And 576 says that the board shall act in accordance with any general directions of the government given to it by the minister, but subject to this section, when exercising and performing those functions, powers, and duties, be subject to the control or direction of no other person or authority. I'll come to that in a bit. Then I go to page section 11, just lower down that page, which is the conflict of interest, declaration of interest provision. And I just wish to make a point that insofar as these provisions go, these are all provisions which were raised in the case of the respondent, but they are all provisions that come into play only after an appointment is made. What we're dealing with is the eligibility requirement ab initio in terms of being eligible to be considered to be appointed in the first place. And then I take you next to page 595. And I take you to this simply to correct something which was in the case of the respondent, and I'll come to it in due course, which is simply the rates of contribution. The rates of contribution shall be related to the amount of the earnings of the employed person in respect of whom the contribution is payable. That is to say, the contribution payable in respect of an employed person shall be based on the assumed average weekly earnings, etc., into the class. And then I take you finally to page 617. And there you will see section 56 at page 617. And this is simply to show that the rates of contribution and the rates of benefit, as shown in the tables of the second and third schedules, may be amended by order of the board after actual assessment and so on. I make this point because the respondent in the written case seemed to have suggested that the board couldn't amend the mandatory rates, but they can, as is clearly evident from section 56. And the board has, in fact, my lords, my lady, changed the mandatory contribution rates and the rates of benefit on several occasions, and that is gazetted in legal notices that I can easily provide to the board if necessary. So the short point is that insofar as the minister submits to the board does not set the rates of mandatory contribution and submits that we might have over-egged the importance of the board's functions, which you'll find in their written case at paragraph 9, page 534, and paragraph 24b at page 540, we say that that is incorrect, because section 56 makes it abundantly clear that the board sets both the rates of contribution and the rates of benefit. If I can go back to section 3.2 at page 572 to just interrogate that provision. We say that when we say that person stands apart from those sectors, I mean, if one were to think of, there'll be several analogies one can think of. I mean, in the United Kingdom, for example, the communications ombudsman has to be independent of the communications industry. And what do we mean by that? We mean he must be someone, sure, he or she should be someone who is not significantly connected to, or associated with, or involved in that sector. If the ombudsman, for example, were to have significant holdings in BT, British Telecom, or O2, or EE, we'd say that they were not independent of the communications industry. I mean, if there was, for example, a scientific study published, you might find that an independent reviewer or researcher's comments, what we mean on the study's findings, but what we mean is that they're not affiliated with the research team or the institution that conducted the original study. They are not significantly connected to or associated with or involved in that team or institution. So we say the minister's test is narrower in that his test involves asking whether the person is subject to control or influenced by government, business, or labor. And we see that from paragraph 3 at electronic bundle 530. They say that the person will only be ineligible for appointment or want of independence if, and I quote, either government, business, or labor has some mechanism of legal or actual control over the nominee. Now, it's not readily apparent as to how it's possible for a sector of the economy or society to have a mechanism of legal or actual control over the person. But the minister's construction will always require the identification of some person, entity, or group within that sector that has a mechanism of control over the person. But we say that is directly inconsistent with Parliament's careful framing of Section 3. Unlike elsewhere in Section 3, Parliament in Section 3(2)(d) expressly referred to business and labour rather than the associations most representative thereof. So we say the minister's case is in effect. It requires words such as the associations most representative of to be read into Section 3(2)(d). They say in their written case at paragraph 11C at Electronic Bundle 535 that it is, and I quote, it is the presence or absence of an obligation owed to a nominating party or association that is key. But that is not what the text says. The text simply speaks of being independent of business, labour, and government, and it is broadly framed, and that is the choice by the legislature that ought properly to be respected. Even if it means the pool is whittled down, if that is the legislative policy and intent, because of the importance of the role of the chairman in Trinidad and Tobago, then we must respect it, even if we disagree with that policy. It is not to say that the smaller category is going to be so dwindled and so small that you cannot find someone to be a chairman. That's not the case at all. And that is why I made the point that previous associations, you would not necessarily disqualify someone. I mean, we accept, of course, therefore, that our construction is a little broader, but we think it's amply justified given the important role of this board. This board, my lords, my lady, it controls close to 8 to 10% of the assets of Trinidad and Tobago. It's very significant, and we say that it is. We say that the role of the chairman is just simply far too important to not give the regard and respect and weight that Parliament intended to the substantive requirement of independence in the context of being independent of business, government, and labour.
Well, given the importance of the job, as you say, if they are controlling and investing 10% of the assets of Trinidad and Tobago, it can't be a job confined to the chairmanship, can't be a job, surely, confined to retired people.
Well, no one is suggesting that it's confined to retired people, but even if it were, that would simply mean that the potential for having skin in the game and any conflict of interest is going to be, virtually non-existent or de minimis. But one can readily see on the converse side, my lord, that if you're head of the largest conglomerate, one can easily see why investment of those funds could happily or unhappily coincide with your other business investment, private interests, and personal interests. And it's either you declare it or not, as the case may be, but we have serious problems where those things are concerned. So the idea would be not to have someone who, look, Mr. Ferreira's, it's not as if his academic qualifications are quite stunning. I think he has a university degree, quite frankly, even. So it's not to suggest that, it's not to say that one is, on the particular facts before you, that this was an appointment that is so exceptional that it ought properly to be defended at any cost. It's not the case at all. On the merits of the particular candidate, I mean, if it is precisely why the safeguard intended by Parliament should be enforced and respected, because how on earth could you put someone who is not even a university graduate, who is in a family business that has historically been around through pre-colonial days and enjoyed certain privileges and advantages, in charge of this important board? How on earth could this possibly be independent of government and business?
Can you just so the candidate in this case, you say he's a chief executive or a high up executive in this conglomerate which employs a lot of people. He's presumably also an employee, but he's not likely to be at any stage in his future life dependent on the benefits which dependent for putting food on the table on the benefits which this national board is determining or is dealing with. So his involvement as an employee is unlikely to influence him, but your concern, as I understand it, is that if the national insurance contribution goes up significantly or some new benefit is proposed to be introduced, then his role in this conglomerate means that he will realise that actually quite a lot of their money is going to have to go to contributing to this increase in benefits or this new benefit. And what you say is that he's then connected with business, even though it's not going to personally affect his own financial position. His connection with the company means that, given that he has to have the best interests of the company at the forefront of his work as a director, how can he also be independent when he's deciding those sorts of issues? Is that your concern?
Well, yes, Milady, because the fiduciary responsibility he owes to the conglomerate is to act in the best interest of that company, and he will benefit because the rates of contribution impacts on the bottom line. In Trinidad, the dialogue, the constant tension here is employers would like to obviously see the rates of contribution never change, or if it changes, it should be decreased because it impacts on their bottom line. It means less dividends for Mr. Ferreira. It means less profit for the company that is on which the dividends will be based, and the value of your shareholding will go up or down. But so that's the way, that's why it's so dangerous, quite frankly, to allow for the particular appointment to go forward. The conflict is clear. You can't. This is not a position that allows you to serve two masters by acting in the best interest of the workers and the insurance and the national insurance scheme, whilst at the same time acting in the best interest of your private conglomerate. It just wouldn't work that way. And as Milady has rightly pointed out, because he's not dependent on these insurance payments for his retirement, for comfortable retirement, it means that if you tinker with the level of contributions and so forth, well then it's the workers who suffer, not you. So he doesn't have the same leveling of influence or motivation and incentive as the case may be. So it's a very tricky, thorny situation, and that's precisely why I think coming out on the heels of the Black Power Revolution in Trinidad, where the working class rioted, I think that's why Parliament in Trinidad was very careful to pay regard to the workers' concerns about, in a post-colonial society such as ours, where business empires were inherited and continue to be dominate the landscape by virtue of inheritance and not merit and ability. This man has a diploma. He has a diploma. So that, I mean, even the judgment and the case is prompted by the peculiar factual matrix in this matter. The man resigns. He could have remained there and served his full term in the public interest. But the minute the government changed and political relationships emerged, he resigns. The government couldn't move him. He could have served out his full term. But he treats his own appointment as though he was a nominee of the government, of the political administration of the day. So, the facts speak for themselves, and they compellingly do so. And this independence requirement is far too important a safeguard to protect the people of Trinidad and Tobago for us to, because the category of persons will be smaller, but perhaps more erudite and far more experienced and knowledgeable, that is a basis to ascribe, a meaning to the word independent that just doesn't match the socioeconomic and political realities of the day. So it is, my lords, and it's not just about the level of contribution. The fund, we've seen, you will see from the evidence, there are serious concerns about the solvency of the fund. You will see as well that we have been considering things, not just the rate of contribution, but the age of retirement. If you have to increase the age of retirement because the fund needs to get more contributions before it can sustain itself and pay out, the kind of benefits, what would an employer say? What would the employer's interest be when they collide with that of the working class? When it collides with that of the government even? It's just too messy, and it introduces far too many hypersensitive socio-political complications that can be easily avoided if we stick with what Parliament intended and say it's someone independent of government, business and labour, and simply define it as someone who is either not currently connected and significantly connected with those sectors, and that's the point here. The board can, if we deal with the facts of this case, this is a person who was in the ring at the present time he was appointed. He was currently actively a lead, not a participant, but a leader in those two sectors. Remember, we showed how many other boards he was politically appointed to. He was politically appointed by the political administration to serve on many other boards. So to divorce, all of those connections and ties, the political gift of a board directorship is a big deal. You don't appoint someone who is not connected to the government, who you don't have political loyalty and allegiance to serve on your boards. That's not the way it works. So the individual in question, armed with his diploma, armed with his obvious connections that only the head of one of the largest conglomerates could have, given the level of interface with the business, the only reason one can isolate is the minister says he knew him for 20 years.
So
that's not relevant.
Can I, Mr. Ramlogan, as I understand it, your submission is that Mr. Ferreira had a significant connection with business. I'll leave aside the government side of it, because I think your submissions would be the same if he had never been a government nominee on this board, wouldn't it?
Fair enough.
Sorry, that's yes. I didn't. You agree?
Yes.
So
I agree.
I'm just going back to the question Lord Hodge asked you earlier about connection with Labour. I'm trying to understand, for the purposes of this provision, what a significant connection with Labour would be.
I think a significant connection with Labour would mean that you're actively involved in representing the workers' interests in active trade unionism.
So that suggests, in that context, that independent of Labour does carry the sort of connotation of being involved in an association representing Labour.
I would say yes, my lord. Yes,
because that rather takes you back to paragraph C of section 3.2, which you were earlier at pains to point out there was the difference between C and D. So, I mean, if the relevant significant connection with Labour is being actively involved in an organisation representing Labour, why is that not the same test for independence of business?
Yeah, my lord, I see the force in that. My lord, I mean, it says independent of government, business, and labour.
Yes.
And I would have to say that independent of labour, it would obviously include if you're involved in active trade unionism. But what I will say, my lord, to that is that you're not actively or significantly connected or associated with the labor market in the sense that you are something to do with industrial relations, perhaps, as it were, which is a little different to being involved in the limited way of an association. But if you were involved in industrial relations, a little broader, something to do with having a stake, a stake as a stakeholder in labor.
Well, does that extend beyond effectively trade union activity?
Yes, it would. It would, in my respectful view, my lord, it would.
To include what sort of categories of person?
Well, my lord, let's take it this way, my lord. Business, labor, and government are different types of sectors. Independent has to carry a broad meaning that allows for each of those sectors. For example, you can own multiple businesses, but you can't generally be an employee of necessarily so many different businesses. In the case of labor, my lord, I can say that if you were involved in any form of advocacy on behalf of workers, if you were involved in anything to do with industrial relations, I think that would be the way I'd look at it, my lord.
Yes, I mean, I think you accept that just being an employee yourself isn't a significant connection with labour, and I think that would be right even if you were someone who might in future become dependent for your life, for living on these benefits if you fell on hard times. But I mean, for example, we have in this country a number of advocacy groups who regularly represent workers in court proceedings, in test cases, and non-profit groups that do that sort of thing. That might be a broader category than just trade unions who... You mentioned advocacy on behalf of labour workers. That certainly we have those sorts of groups here. Sometimes they instruct Mr. de la Mare.
I will be happy to have him as chairman, I assure you. But I mean, I see the I see the problem my lord identifies. But my lord, my answer to it is simply that I mean, if you're separate and apart from it in the sense that you're not actively involved in some form of workers' rights advocacy, some representative dealing with broad representation of worker rights or advocating and promoting the welfare of workers, etc. I would say that that's where I'll pitch the ball.
Yeah.
But why isn't the way out of these difficulties that what you're really concerned about is someone who is going to rise above and not be influenced by any one of those three sectors? Why isn't it the obvious answer that the person is independent in the sense that whatever their background, they will not be seen as someone who is partisan to one of those three interests?
I mean, the Act says independent of government, business, labour, and I think the underlying tension that would have been weighing heavy on Parliament's mind at the material time would be the heavy, thick dynamic between these three groups, and in particular, business and labour. And I think that merely saying someone who will enjoy someone who will, not be under the influence or capable of rising above that might be far too far too subjective. I mean, every Minister of Finance will appoint their primary school friend or neighbor next door whom they think can be, an independent person, but without reference in regard to the substantive legal requirements in the Act, which is that they must be independent, not in just your opinion, but they must fall within the pool circumscribed by the Act of being someone who is on an objective basis, independent of business, government, and labour. So
but the objectivity may well be that it's been seen in the past that this person is someone who, whatever their background, has risen above sectorial interests. And if you've got that person, why aren't they independent?
Well, they're not independent because A, they served 2 terms as the government's nominee consecutively, immediately prior to their appointment. B, they happen to be the head of one of the largest conglomerates in the country. And when you combine those 2 factors, either take them individually or in combination or together, it's simply the facts that require an objective evaluation.
Well, let me put this to you. Say we have person A, who is a retired employee, hasn't worked for 5 years. It's known that that person always favours, let's say, Labour.
Yeah.
As against that, you've got a person who is a proactive businessman who is widely respected for actually, in the past, making it sufficiently clear that he represents or rises above any sectorial interest. Now, which of those people do you think would be regarded as independent?
Well, I mean, the person who is known to be pro-Labour obviously would not be someone who...
Why not? You told us that there's a cooling off period, he's got nothing to do now with Labour.
Oh, well, Milord, you qualified it by saying he's known to be pro-Labour, and if he's known to be pro-Labour, I would say that would affect his ability to fall within the category of persons who are independent of business, labour, and government.
Well, in that case, the test is wider on your argument than sectorial, than sufficient connection.
Well, my lord, the prior history and experience of the person would be a relevant consideration to which the minister ought to have regard in making an evaluative judgment with respect to the independence requirement. That is what I'll say in that regard. And the minister, it would be a relevant consideration for the minister to consider that this person has demonstrated propensity to be in favor of a particular group. But if the person, and that demonstrated propensity, if the person is, for example, actively, presently involved in expressing such views and advocating the interests of labour, the working class, well then that's a different story. With respect to the businessman, firstly, there is no real evidence here that this particular individual was widely respected. That's not the evidence. But more importantly, even in that case, you would have to have regard to the objective facts that surround the particular individual.
I think you're saying, Mr. Ramlogan, that this person objectively would be influenced by business.
Well, yes,
we're trying to work out. It seems to me that you're not actually criticising the test. You're saying its application in this particular instance is in relation to someone who objectively would be influenced by business.
Well, my lord, that is in fact the alternative part of the case. We have said that, look, even if we are wrong on the test, because there might be 2 different ways of looking, it might be a case of looking at the glass as being half empty and half full, depending on which test you use. But there might be different routes by which one scales the mountain of independence. But the view at the top is the same for both the appellant and the respondent in terms of the independence. But what we do say is, when you arrive at the top of that mountain and you survey the landscape beneath you, it is not possible to say that this particular individual could have satisfied the independence requirement. And that is why, my lord, the case is rooted in the facts that prompted the case to be filed. What was offensive here to everyone was the fact that someone with a diploma, who is head of the largest conglomerate and who was serving as the government's nominee for 2 terms, seeking to promote and advocate the government's interests and protect the government's interests.
Can I, Mr. Ramno, can I just cut you short there? You say that the effect of being the government nominee is that their job as members of the board is to promote and advance the government's interest. But I would have thought, and correct me if you disagree and explain why, that once you have become a member of this board, your job is not to advance the sectional interest of your nominator. Your job is to act like any fiduciary in the best interests of the entity in question, in this case of the board as a whole, i.e. the best in the furtherance of its objectives.
My lord,
And
the short
to that
answer
to that extent, to do so fiercely independent of whatever it is that your nominator is asking you to do at any particular moment during the business deliberations of the entity.
Yeah, well, my lord, it's a bit like in company law to say that the board acts in the best interest of the company, and I readily appreciate that. But the short point is, the tripartite arrangement is such that it would be very artificial to say that they will not be they would not be there to fulfill the interests of the group that nominated them to serve as representatives of that particular sector, as it were. Now, I accept what my lord is saying as a broad proposition, but I'm saying that it would be artificial to divorce it from the socio-political and socio-economic reality of the appointment, which is that they're there as a representative of a particular group or sector whose interests they would be expected to advocate or represent at the level of the National Insurance Board.
Yes, and in section 3, is it 37D?
Yes.
If the appointing body from Business and Labour withdraws their consent for the person to be the nominee, if they make a representation to the minister has to revoke the appointment of the director.
Indeed, so that they are expected, as it were, if you're not towing the line and if you're not really servicing my interests, and I put you there, I can just remove you. So, you know, I say that whilst the analogy does, I understand the analogy, but I'm saying it may not be totally appropriate or relevant for the purposes of assisting us with what's the correct approach to the interpretation, or more importantly, as my Lord Burroughs pointed out, whether or not this particular appointment was offensive, given the stringent nature of the requirement for independence from government with labour. I mean, the short point in that regard, to complete what I was saying, is it's not just that he was, as it were, in your face as the current serving government nominee, head of the largest conglomerate, but also that he was also very politically connected to the government, as evidenced by his other directorships that he was appointed on other state enterprises to serve as the government's representative. So that when we put all of that into the basket, we say that this case can in fact be decided on the basis of the unique factual matrix, the peculiar factual matrix before us, without necessarily getting into the messy detail of, whether it's significantly connected to or associated with or involved in the sector,
Well-
whether it's subject to control or influence.
Well, I don't see how we can do that because you've got two cases. One is what is the correct interpretation of the concept of independence, and that means we have to face up to the question: is the significant connection test correct? And you've got a separate ground, which is rationality.
But
and you're really saying whatever test is applied, this individual cannot be seen as independent.
But the rationality test is largely academic. I mean, we're hearing this appeal really on the question of construction.
Yes.
Yeah, well, my lord, I believe, the state has indicated that they are not of the view that the matter is academic. It wishes to have the matter decided. And we think that there are serious underlying rule of law issues that underpin.
But they want it decided. They want it decided, Mr. Ramlogan, for the future, because they want to know how to apply this particular section. That's as I understand their position. And that requires us primarily, at any rate, to try and tease out what these words mean, rather than focusing on the facts of this particular case.
Well, my lord, I think, with respect, it would do us well to do both, because, my lord, I say that, I mean, you've got the submissions before you, but I mean, although it's a matter for the board's discretion, we think it's a very important factor that the minister does not submit that the board should decline to hear the appeal on the basis that it's academic on either grounds. The minister has accepted the fact that the board's judgment could provide valuable guidance for the future. In fact, the email which was sent to the court says that the minister, and I quote, does consider that the question of principle posed by the language in section 3.2d is an important one which it would wish to see authoritatively resolved so that the future application of that provision takes place against a secure understanding of the requirements of the Act. And given the stage we've reached, my lord, I would say that, it should, the board should in fact decide the matter. It has the full written cases of both parties. The rationality challenge concerns a ministerial appointment to an important, very important office. And there is a huge public interest backed by rule of law considerations in knowing whether the appointment will be made. I mean, the issue is not futile. If it is successful, the board can grant appropriate declaratory relief, as the case may be, or articulate its finding in the course of its reasons. But the guidance would be important about in the realm of what is permissible decision-making under Section 3.2d. And given that the minister is not taking the point that the board should hear the rationality challenge, and there are no additional costs to be incurred, as the case may be, we say that it would be rather unfortunate if we shy away from dealing with the case as originally. But not any case that challenges the appointment.
Well, say, Mr. Ramlogan, we took the view that the rationality challenge is purely hypothetical. It's got no significance. We're entitled to do that.
Well, not, of course, I accept that. The board, it's a matter for the discretion of the board. Yeah. But what I do say, my lord, is this. My lord, our Judicial Review Act has a specific procedure for challenging appointments to public office. It's replaced the now abolished old ancient writ of quo ranto, which was there before. But we have a specific statutory right to challenge appointments to important public offices enshrined in the Judicial Review Act. And my lord, the short point I make is, by the time these challenges are decided by the judiciary, even in the High Court, by fluxion of time and protracted case management, the appointment inevitably has come to an end. And it really does turn the rule of law on upside down in its head. If we take the position that, if the appointment is no more, then we can treat it as academic, because then it renders nugatory and meaningless the right given to citizens by the Judicial Review Act to make this challenge to appointments and to determine the validity of the appointment. What we see, I've been involved in a few of these cases, and what we see is that the state would, you can protract your case management directions, ask for extensions of time, bearing in mind the finish line of the appointment, and what will happen is that no one will ever get a decision from the board in a challenge to a public appointment, because when it comes to the board, by a fraction of time, the appointment has come to an end. So I do wish to say, my lord, whilst it is a matter for the board's discretion, I do want to impress upon the board how significant and important this challenge is for us in Trinidad. It's an extremely important matter that generated a huge amount of public interest and grave public disquiet and consternation. So, my lord, I would respectfully crave the indulgence of the board that it does in fact treat with the case on its merits, because, you know, to do otherwise would really render valueless any challenge to appointment to a public office, given the realities we face in terms of time. A section in the Judicial Review Act, just so that I can, it's section 18.
Section 18.
Section 18.
Is that in the bundle? Sorry.
No.
No.
I don't believe it's in the bundle, no, my lord.
No.
So that's the...
Is that the mechanism which has been used in this case?
It is indeed, my lady. Yes, it's section 18. I can read it, my lady. It says, it all deals with, you know, grant. It says where a person brings proceedings alleging that another person is not entitled to act in an office to which the section applies, and it has a whole section about the public offices it applies to and what are the powers of the court to grant injunctive relief, or as the case may be, to grant appropriate declarations and so forth. But that right was put on a statutory footing in Trinidad because of the demonstrated propensity by governments to appoint persons who are party hacks, cronies, and people who are without reference to the legal requirements and the intended safeguards for independence. And my lord knows the kind of colourful cases we from the Caribbean managed to cough up. I mean, the law reports are littered with our contribution to the jurisprudence by virtue of cases that would otherwise not have arisen in the United Kingdom or other countries. That's the reality of a post-colonial society in the era that we exist. So my lord, I say that we say that when Parliament established the board, we say it was obviously mindful of the important role it would play, and it chose to set up a board that represented these three groups. The Court of Appeal had suggested that the nominated directors did not represent government, business, or labour in any meaningful sense. And we explained why that was incorrect in paragraph 53 of our written case, which you'd find at page 521. And interestingly, the minister has now accepted in their submissions that is in fact correct.
Sorry.
And
521, 53.
yes, 521, paragraph 53, and the minister's acceptance that our view is now correct. You will find that at paragraphs 11, 12, and 14 of the response submissions, which is at page 535,
Right.
536, and 537.
Thank you.
My lord, if I may just be permitted 1 second. If I can just take it to page 535 to illustrate the point, because my Lord Briggs, I think, raised this point with me just a short while ago. If I take it to 535 at paragraph B.
Paragraph,
See,
I'm sorry, paragraph which?
11B.
B, 11B, thank you.
It says in B, the independence is obviously not juxtaposed to the position of the nominated directors. The independent chairman is not nominated and is not subject to all that nomination entails. And nomination does entail, as the wider scheme of the Act reveals, that the director in question can be expected broadly to further the interests of the party nominating them, as expressed by the nominating party / representative associations from time to time, and any failure to do so may be consequential. If I take you to page 536, paragraph 12, last sentence in paragraph 12 on page 536, nominated directors thus have no security of tenure, and their appointment may be curtailed as of right by their nominator, just like a director appointed as of right by a shareholder. And such may be because the nominator considers that they have not acted in accordance with the expressed wishes of the nominating party, and so as adequately to represent the interests of the nominating party. I take it to page 537, paragraph 14. But such section does not preclude a nominated director from giving effect to the instructions, wishes, or interests of his or her nominator, so long as doing so is consistent with his own duties or own duties of the board. As the appellant has correctly pointed out, the position is closely analogous to the position of a director of a private company appointed by a shareholder. So long as it's consistent with the prior overarching duties of the board, nominated directors can continue to represent the interests of their nominating party. For instance, preferring a course of action, A rather than B, where both courses were open to the board in law. Under section 37 above may explain the nominating party can require the revocation of the appointment if they fail to do so. So they've accepted the correctness of the submission we make in that regard, that they are there to really, within the framework of the law, advocate and represent and nominate the interests of the nominator. And it's against that background, my lord, we say the purpose of the requirement of independence is to ensure that no one stakeholder can monopolize the board's policy direction and debate in circumstances, given the important role the board plays, and where the interests of the three key stakeholders would oftentimes conflict and be competing with each other. The healthy dynamic and tension that produce is one that compels us to say that the independence requirement is such that the chairman should be someone who is, not connected to or associated with or involved in those sectors, or even if you want to say someone who is not going to be perceived to be subject to the control or influence objectively of those sectors. He must be able to mediate, as it were, the competing interests and concern of those stakeholders without having the shackles of those perceptions attached to his shoulders. And that is why we say the purpose is advanced by our construction. It's not advanced by the minister's construction, which allows unlimited involvement in an association with any of the three stakeholders, so long as there is no mechanism of actual or legal control. We say that just can't be right. My lord, with respect to the minister's arguments, we've dealt with why we say their test should not be preferred. But in any event, both of the tests, they seek to suggest that our test is somehow not available on the literal plain meaning of the word. And we've dealt with this in our written case at paragraphs 48 and 49 at pages 519 to 520 of the electronic bundle. And we say that although in their written case at paragraph 11A at electronic bundle 535, they refer to the Court of Appeal's judgment 21, paragraph 21, page 454, as defining independent to mean free from control or influence. But it doesn't mention that the Court of Appeal's definition also included not connected to or separate from. So that both meanings are available, quite frankly, on a plain and literal construction. And perhaps There may be different ways of saying the same thing, perhaps, one may say. But we say whichever it is, and however one constructs the formula, Mr. Ferreira would have offended. And that is the concern. Now, I mean, for example, I mean, the concept of independent politicians, it means politicians who are not connected to or associated with or involved in a political party. People who've achieved success independent of their family wealth. It means that, you know, their success is not connected to or dependent on their family wealth. So that insofar as those examples will assist us, we say the minister's argument, in effect, the independence requirement is the obverse of the position of the 9 nominated directors. He argues that because the nominated directors represent their nominators and can be removed if they do not act in accordance with the nominator's wishes, the independence requirement attaches to the chairperson must simply be the obverse of this. And you will see that in their case at paragraph 5B, electronic bundle 531, at paragraph 11B, electronic bundle 535, paragraph 12, 536, and paragraphs 17 to 18 of 538. But the key difficulty with this argument is simply that it makes the word independent somewhat superfluous. If Parliament had intended for the chairman's position to be the obverse of the nominated directors, it could simply have provided that they would be nominated by the minister and would have security of tenure. But Parliament went further and required that the person nominated by the minister must be independent of government, business, and labour. That goes beyond the mere issue of security of tenure for their term simpliciter. And in any event, these concepts about removal and conflicts of interest that have to be declared and so on, they all enter the picture post-appointment. What we are concerned with is the eligibility criteria ab initio that governs the initial appointment of the chairman, as opposed to the safeguards that the Act puts in place to treat with the functioning of the board post that appointment. And we ought not to conflate both. I mean, to put it another way, the Act provides that the chairman with security of tenure, because apart from the exceptional circumstances listed in 7A to C, can't be removed from office. And to that extent, the minister's case appears to me that this guarantees the chairman's independence within the meaning of section 3(2)(c).
Did you say, Mr. Ramlogan, I may have misunderstood, that there were similar statutory provisions in other similar jurisdictions which have not used this precise formulation? You may have referred us to them in your case. I'm not sure I'm got them in my mind. Are you able to help us with that?
Yes, please, my lord. I can take you to that page. But I can get that. I can get that for my lord. Now, I think it's anyways, it's in our submissions in the Court of Appeal. We were asked to do a comprehensive legislative comparison, and we did in fact do that. If I go to page 328, my lord.
Thank you.
At page 328, you will see a section headed Comparator Legislation. And if we scroll down, we've identified the countries, and what we said it is submitted that the degree of independence required was a high one, as will be set out below. The interpretation sounds in the statutory text and the policies that underpin it. It also made clear by reference to legislation making provision for the establishment of the boards in other countries. In short, Trinidad and Tobago, it's clear the chairman may not be drawn from the ranks of the directors nominated to serve other interests on the board, whereas legislation in other countries permits this kind of doubling up. Further, legislation in other countries does not go so far as to require by express words the independence of the chair in vis-a-vis other interest groups, whereas this is expressly spelled out in Trinidad. So, for example, Barbados. If I scroll down, we've set out the legislation, and all Barbados says in subsection 5 is the minister shall appoint 2 of the members to be respectively chairman and deputy chairman. And you've got the same tripartite arrangement, mind you. 2 persons appointed by the minister as representing employers' associations, trade unions, and 3 other persons representing the minister. But all it says, the minister shall appoint 2 of the members to be chairman and deputy chairman. That's Barbados. St. Lucia, on the next page, paragraph 53. St. Lucia says, the minister shall appoint the chairperson and deputy chairperson of the board from amongst the members, who shall, with the other members, hold office for a period of not exceeding 3 years. In Grenada, paragraph 54, the minister shall appoint 2 members to be, respectively, the chairperson and deputy chairperson, who shall, with other members, hold office for a period not exceeding 3 years. St. Vincent and the Grenadines, paragraph 55, over onto the next page, subsection 4. Cabinet shall appoint 2 members of the board to be respectively chairman and deputy chairman of the board. St. Kitts and Nevis, paragraph 56. Composition of the board.
So the main point is none of these have any requirement of independence as such.
That is the point, my lord. And the Trinidad and Tobago Parliament, being as it is, looking closely as we do with what's happening with our neighbours, there was our unique socio-political experience in Trinidad is what prompted us to insert this specific requirement as an important procedural safeguard, given the unique complexities that Trinidad has in terms of its racial, religious, politics, and the undercurrents Trinidad is unique, because we don't have these problems do not replicate themselves in other islands, because you don't have the 2 majority races with 2 majority parties competing for political power, for example. You have, or the other societies are by and large racially homogeneous, and they don't have some of the underlying complexities that bedevil our politics in Trinidad. So that is why when we look at, that's why if the intention was the minister can simply appoint someone in his judgment and discretion without being circumscribed by law to a pool of potential identifiable legal candidates, then the Act could have simply made a provision to that effect, to say the minister shall appoint a chairman. Stop. Imported into that would be someone whom he likes and someone whom he thinks could be, a good mediator of conflict at the board and someone who can be respected and all of that. But that's just not what Parliament did. So, my lord, we say, so that's what we say in relation to that. Now, my lord, if I can move on now to a different point, because I think we've dealt with those points, some of those other points. Now, my lord, my learned friends say, for example, that they cite numerous provisions that they say supports their contention. Like, for example, Section 9, where you can act with respect to policy directions. That applies to the board as a whole. It doesn't apply to individual directors. It doesn't say that they're not free to advocate and represent their sectarian interests. The conflict of interest provisions, respectfully, we don't think that is of any assistance in how to interpret it. We say that all Section 11 does is to declare an interest largely that tracks the obligations of directors, for example, under Section 177(1) of the UK Companies Act 2006. But the purpose of Section 11 is simply to regulate how directors must manage their conflict of interest. But it's not concerned with the broader question, which is unique to the board, and which does not arise for private companies, of ensuring that the board is evenly balanced as between the three stakeholders in the national insurance system. If the minister's submission is were to be correct, I mean, there would be little or no work for Section 3.2d to do that isn't already captured by some of these provisions. And we say the independence requirement as a condition of eligibility rather than as part of an ongoing control mechanism is what one has to have regard to. The board remains evenly balanced as between the three key stakeholders, and that's not simply a question of the chairman declaring an interest or recusing himself. It's a question of appointing someone who, unlike the 9 nominated directors, is simply not significantly connected with or associated with or involved in government, business, and labor. And we say that the sections they rely on perform quite different functions. In that, they apply to Section 11 applies to all directors, whereas 3.2d applies specifically to the chairman, and it's the more specific provision. And although it might overlap at times with 11, it's not a difficulty. There's a difficulty with the appellant's construction. The minister tries to suggest that Section 11 is the more specific provision, but that is simply unsustainable. Now, my Lord, insofar as we say that as a general rule and as a general proposition, past experience is probably less likely to render a candidate non-independent, but present significant association or connection or involvement with government, business, or labor will and should disqualify such a person. And we say that whatever the test is, it should be flexible to take into account such matters. My Lords, if I can go quickly just to speak on the rationality challenge, just briefly. The Lords would be familiar, of course, with the concept, the principle of Wednesbury unreasonableness. And what we say is, we've dealt with this in our written case at paragraphs 62 to 66, at pages 524 to 528 of our written case. And what we say is that we would like to note that, in addition, because Section 3.2d refers to the minister holding a certain opinion, that opinion must be objectively justified by the relevant facts. My Lords will find that the reference for that proposition, which was accepted in the courts below, at paragraph 40 of our written case, at page 517. The appointee's connections are manifestly incompatible with independence, making the minister's opinion in this case simply irrational. Appointing someone with clear alignments underlines the board's credibility and violates the intent, purport, and spirit of the Act. It must be reasonably supportable and consistent with the purpose of the Act. The only evidence relating to the minister's decision that Mr. Ferreira was independent within the meaning of the law is the minister's affidavit, which you'll find at page 149, and it came 5 months after the decision was made on January 20th, 2020. And we've gone through that affidavit, we've analyzed the affidavit evidence, and I want to stress 3 points. He was, firstly, as I indicated, the government-nominated director for 4 years preceding his appointment as chairman. His capacity changed overnight. On the 19th of January 2022, he was a serving government-nominated director, advocating and protecting their interests, and then he was suddenly a chairman overnight that was supposedly independent of him. As the government-nominated director, he would have represented the government's interests, and he was subject to the legal and factual control and influence of the government. And it's important to bear that in mind, because even on the respondent's test, because he would have been subject to the legal and factual control and influence of the government and subject to be removed.
Well, Mr. Ramlogan, if I remember, the power of a nominating body to remove their representative in Section 3.7 was a power for the business and labour. The government didn't have the same power to replace. Am I not right about that?
Yeah, my lord, I saw that. It's probably correct, save and except that the Interpretation Act says that the power to appoint carries with it the power to disappoint, as the case may be. But I take the point that it's this specific section in the Act which pertains to the chairman is such that there are limited grounds for removal. But the point I make, my lord, is the question of removal conceptually comes down the road. What we are concerned with is the eligibility requirement that determines a legal and valid appointment ab initio.
Yes, but no. My point is, you were saying when he was the nominee of the government, he was controlled by the government the way that the business and labour nominees were controlled, and I was just calling that into question because Section 3.7 gives that power to business and labour, but it doesn't give that power to remove the nominee to the government.
Yes, my lord, that's true. My lord, but I hasten to say, my lord, I think that the government will and must surely have enjoy a similar power. One would assume, and if they don't, that makes our arguments even stronger, because it means the government, knowing that they cannot remove their nominee, would appoint someone whom they have the utmost political loyalty and respect and allegiance with. So that when they appoint Mr. Ferreira, it would have to be a presumptively close political relationship that he enjoys such a high level of confidence from the political administration of the day. They knew that by putting him there, they wouldn't have to worry about having to remove him, because they can't, but he will faithfully and loyally execute the mandate and policy of the government.
Yes. This is a factual matter that I'd like clarified. I've read Mr. Maharaj's affidavit, and he refers to concerns expressed about the appointment of Mr. Ferreira as chairman, which seems to, in I think the Guardian newspaper, and it seems to be focused on the fact that he'd been the government nominee immediately before, and then goes on to say he's got these business interests. And there was a debate in Parliament where an opposition senator, I think, challenged the appointment, which was I think the 8th attachment to his affidavit. We don't have that, so I don't know the grounds on which the political opposition was made. But certainly in Mr. Maharaj's affidavit, he seems to have relied on the fact that he'd been a government nominee and the fact that he had these business interests, rather than any personal attack based on evidence of political cronyism. Is that fair?
I would say that's fair, subject to this, my lord. In the Court of Appeal in Trinidad, in the case of ETEC, the Court of Appeal in a unanimous judgment said that we must accept as a political reality in Trinidad that these appointments are made presumptively on the basis of political loyalty and allegiance, because that's what's that is the reality in Trinidad and Tobago. And I mean, I will send the board a copy of that judgment so that you will see that is an accepted fact, as it were, of our political culture.
Yes, well, when that presumably is Mr. Maharaj's underlying concern, which has prompted this challenge. But my point was simply that it seems to be he's not making a personal attack on Mr. Ferreira's active pursuit of the business interest or the government interest. He is relying on the objective facts of the fact that he was a nominee and that he's a powerful businessman.
Yeah, indeed, yes, my lord. I don't think I need to descend to drill down that deep, and my lord, I'm grateful to the board for that rather instructive observation, my lord. What we do say is that it's almost a case of an irrebuttable presumption that if the government nominates someone in circumstances where they do not enjoy the power to remove that person and they're there for a fixed term, it is almost an irrebuttable presumption that that person would be someone who is A, politically aligned, B, someone who would be loyal, politically loyal and faithful to the government of the day, the political administration of the day. And by that in and of itself illustrates why this particular appointment would have been one that ought not to have been made because it would offend the Act.
Thank you.
Much obliged. My lord, so we say, yeah, so we say, my lord, we simply say, my lord, that look, we say that having regard to these factors and given the peculiarities that arise in Trinidad, we say that the decision was just simply not objectively justifiable on the basis of the relevant facts. And we say that, you know, we must be careful not to fall into the trap of looking at his roles or interests individually in deciding that each of them is not significant enough to render him independent and concluding that he was independent because Section 3.2d required the minister to examine all the relevant facts and circumstances that might affect his independence in the round and a consideration of where the government or the business sector exercised any actual or legal control or influence over Mr. Ferreira. And those facts and circumstances include his employment history, appointments, directorships, membership of associations, past or present business or commercial interests, and matters of the like. And what we say, the fundamental flaw in the decision-making process here is that the minister simply did not evaluate in a genuine and meaningful or in a proper and lawful manner these relevant facts. And had he done so, it would have disqualified this particular candidate from being appointed. So, my lord, so that is. Yeah. If I can take in response to the point, I think query was raised by my lady earlier on, and I just want to take you to the actual application for leave. You'll find it at page 5, and you will see that this is, it was in fact brought as a claim for judicial review, and relief that we sought was a declaration that the decision to appoint was null and void of no legal effect. This is on page 5, going on to 6. I don't, certiorari obviously is not relevant anymore, and it seldom will be. And you will see that we had sought an injunction which wasn't granted. And if I may take you to the grounds to show you the Judicial Review Act.
The injunction was not granted, you say?
That is correct. Yes. Lady, if I may take you to the relevant law to set out where the act is, section from the act is set up. Yes, it would be, if I take you to page 15, those are the grounds pursuant to the Judicial Review Act, section 5.3. My lord, I noticed, my lord, I noticed that certain parts of the articles are quoted and replicated in the application for leave, to the extent that the actual exhibits might not be included in what's before the board. So I refer this simply to point out that this was in fact claim for judicial review under a specific provision in the Judicial Review Act that allows for a challenge to an appointment to a public office. And that's why it's so important not to treat it as simply being academic.
So, Mr. Ramlogan, do I understand you to say that on page 5, 2A, that declaration, is still something you're asking this board to make?
Indeed, my lord, yes. Yes, I said that declaration, a declaration to that effect is what the appellant would be entitled to on the particular exceptional factual matrix in this particular case that gave rise to these problems. You see, my lord, you see the danger in this case, my lords, if left untouched, the danger is that it allows for ministers of finance and governments to appoint party. My Lord Hodge is right. We did not drill down deep because I don't think it's necessary to get into the merits and the personality, as it were. But my Lord, if we don't check these things in a fledgling democratic society, what tends to happen is that political cronyism and party hacks are appointed on the basis of the subjective opinion of the minister, or political investors and financiers who control large conglomerates can be appointed. There is no campaign finance legislation in Trinidad, for example, so you don't know who supported and financed which party. And the danger is that people who have vested interests that cannot easily be revealed can be appointed as chairman of these important entities. And this is so important to the working class that if you don't have a truly independent chairman, because the chairman is also chairman of the investments committee, and if you don't have someone who's truly independent, we could find ourselves in a position where the fund becomes insolvent. And you will, my lord, some of the articles that might not have been included, there's grave concern about things like that. And obviously, a further problem is that in the aftermath of COVID, because of the number of deaths that occurred and the unexpectedly large number of payouts that had to be made, it affects the fund. So that, my lord, it's a very sensitive matter. It's one that requires the utmost amount of respect and arm's length in terms of the appointment of the chairman between the politics of the day and to get someone in that position who is not certainly the holder of a mere diploma, the head of the largest conglomerates.
What is the significance of the diploma that you've mentioned several times?
I've mentioned it only because, my lord, insofar as we highlight the importance of this fund, and insofar as we were speaking earlier about the people, about the fact that a successful businessman who didn't inherit, for example, his business empire by just by inheritance, and didn't work to build it himself, such a person might seem eminently desirable, save and except that you may have on the other side of the scale a person who is a prodigal son who inherits a business empire but has a mere diploma, as opposed to a retired professor who has a PhD. And the short point we're making this is part of the public disquiet and consternation lies in those facts, my lord.
So you're saying that you refer to the diploma as showing that he has quite a low level of academic qualification. Is that the point that you're making?
Indeed, yes. To be in charge of the National Insurance Fund for Trinidad and Tobago.
Well,
we're highly society.
You mentioned diploma a couple of times, and I was just trying to tease out what it was that you were saying, and it's a lack of a higher qualification.
Yes.
Thank you.
It's the proportionality of the discretion when one bears in mind the importance of this fund, this is precisely why we say it's presumptively based on political loyalty and allegiance, rather than a stellar resume that commends itself to the board wishing to uphold, where one can readily see why this person was, better than sliced bread, as we say in the Caribbean. My Lord, the quote I wanted to read from the judgment I will send from the Court of Appeal is from a judgment of Justice of Appeal Barrow in the case of ETEC, and it's paragraph 26, and I'll send it to the board. It reads as follows. It is a matter of great public notoriety that directorships in state enterprises in Trinidad and Tobago are much more a question of political patronage and cronyism than it is about competence, and in which the lines between self-interest and the public interest can become blurred. In those circumstances, it is hardly likely that the wrongdoing by directors will be ferreted out before a change in government. I do not, by any stretch of the imagination, suggest that that was necessarily the case, of the appellants in that case. But the point is, that's a unanimous judgment of the Court of Appeal.
Sorry, what are you there quoting from?
That's a judgment of the Court of Appeal in civil appeal in the matter of Civil Appeal 241 of 2023. Kenneth, Julian, and others versus ETEC.
Right, is it in the bundle?
No, it's going to be sent. It's going to be sent to us.
Okay. But of course, Justice Barrow was one of the 3 Court of Appeal judges in this case.
Oh, indeed, my lord. That's precisely why I'm citing that powerful reminder as to what is the political reality of these appointments. Because this particular individual was appointed to several boards, not just the NIB. So it has implications and ramifications for his independence. So, my lords, we say the rule of law and the public interest will be best served by the board granting an appropriate declaration with respect to this particular appointment and providing, as it were, during the course of its reasoning, the guidance in terms that will no doubt assist the Honourable Minister in the discharge of their duties. In fact, my lord, might I say that I don't believe that they've appointed a new chairman, and it's probably in part because they've paused for a cause to at least receive the welcomed guidance that this judgment shall provide, bearing in mind the realities as I alluded to, my lord. My lords, my lady, once the board has any further questions for me, I believe I'm out of time, and those are my submissions.
Mr. Ramlogan, thank you very much. May I make one request, that the attachment to Mr. Maharaj's affidavit, RBM8, I didn't find it. That is the copy of the Hansard where Senator Mark, Senator Mark criticised the appointment of Mr. Ferreira. Just to complete the picture, can that copy of Hansard be sent to us?
Most certainly, Lord. Most certainly.
Any questions? Thank you very much, Mr. Ramlogan. Mr. Dummer, thank you for attending. You're here with an amicus brief only, but to correct any factual matters. Are there any factual matters that you wish to raise with us?
There are a couple that I noticed in argument, and there's a correction I should make from the written case as well. First of all, my Lord asked whether or not the Act applied to self-employed persons as well.
Yes.
It does. Section 2, which you'll find at page 568, defines employed persons, and employed persons include the self-employed. That's the first point. I hope that's of assistance. Secondly, my learned friend pointed out an error in our written case at paragraph 24b, where we suggested that the power to set rates was monopolised by Parliament. He is indeed right that that is in error. The provision that entitles the board to amend by order is section 56, electronic page 617. It does, I think, need to be seen in the full context of the Act, and in particular section 70, which you'll find at page 624. Section 70 says that this power to amend the relevant schedules, which set the rates of contribution and the rates of benefit, is only exercisable after an actuarial review. That's the basis on which the power is exercised. It is not a power, I should emphasise, that attracts negative or positive resolution by the T&T Parliament. So apologies for that error in our case. In relation to the question about section 18 of the Judicial Review Act, which isn't in the bundle and has been raised late, I think it's important for the committee to appreciate that the powers in section 18, at least on my present understanding, hastily gained from the internet, is that that is a power to grant either an injunction restraining the person in question from exercising the office in question, or a declaration that the office is vacant. And as I understand the facts, the position is as follows. Relief under section 18 was sought as part of interim relief, and only as part of interim relief in this case. The relevant references are paragraph 4 of the application for judicial review, electronic page 6, paragraph 4 of the draft order, electronic page 23, and paragraph 63 of Mr. Maharaj's affidavit, which is page 47 of the electronic bundle. As I understand, by the time the matter came before Jacqueline Wilson J, that issue had effectively fallen away because there had been no expedition and no grant of interim relief, and the case was disposed of effectively on a final basis. And there is no mention, so far as I can see, of section 18 in either Mr. Maharaj's argument before the judge or in the judgment. So that matter was raised, as we understand it, on the basis of an interim matter and hasn't been relied upon since. All I can do beyond that is apologise for the lateness of the letter. The tribunal should be absolutely sure that you were written to as soon as my instructions had been received, and I apologise for any inconvenience that this late development has caused to the committee on behalf of my clients and personally. So.
But there is no need for a personal apology. If you don't have instructions, Mr. Villanelle, you don't have instructions.
Most grateful.
Thank you very much for your assistance. Mr. Ramlogan, is there anything there that you wish to respond to?
My Lord, yes, just to clarify, because my junior has quite rightly pointed out, when we filed the papers, we had sought interim relief under the section, the Judicial Review Act, to get an injunction. And the approach taken by the court was, it was more minded to deal with the matter expeditiously in terms of dealing with a substantive case. And that is why the question of interim relief was not pursued, in fact. So I wish to say that for the record. So that the court had said, well, look, it's an urgent matter. They will deal with it expeditiously. And that's how the case proceeded.
Fine. Thank you very much.
I'm grateful, Madam.
Yes. Well, the board is very grateful to counsel for their submissions in this appeal, and we're grateful to you, Mr. de la Mare, for being sort of quasi-amicus once your instructions were withdrawn. We're also grateful to those who have assisted in the preparation of the papers for appeal, and the board will take time to consider their judgment. We will now adjourn.